Third-party contracts in English and continental law. English law relating to contracts for the benefit of third parties has been in an unsatisfactory position for a long time. Reform has been advocated by prominent legal writers, and more than 17 years ago an amendment of the law by statute was recommended by the EWHC Revision Committee in its 6th interim report. It is the aim of this article to consider first the present position of English law in this field, and then to deal with third-party contracts in two of the leading continental legal systems, the French and German. Some of the continental experience may be useful in considering future legislation here. English law. Contract as the basis of the third party's right. The early history of the English law of contract does not show any general disinclination of the courts to allow a third-party beneficiary to sue the promisor. With the gradual refinement of the doctrine of consideration, the courts were sometimes persuaded to deny a third-party beneficiary a right to sue on the ground that he was a stranger to the C0 insideration. On the other hand, special circumstances, such as close family relationship, were held to extend the benefit to the tranger. The law on the contra. C201 rights of a third party under a contract concluded for his benefit did not become settled until 1861 when the case of Tweddle v. Atkinson 3 was decided. This well-known case dealt with an agreement under which the fathers of a newly married couple agreed with each other to pay certain sums to the husband who, it was expressly agreed, should have the right to sue on the promise. Dismissing the husband's action against his father-in-law's executors for breach of the agreement, the court gave as its reason that neither had the plaintiff given any consideration for the promise nor was there any privity of contract between the plaintiff and his father-in-law. Edel T. Atkinson settled the common law rule in denial of any contractual right to a party under a contract to which he is not a party. This rule received a paper read at the 9th Annual Conference cf. The Australian Universities Law Schools Association in August, 1954. 1 Bourne v. Mason. 1669-1 Vent. 6. 86 ER 5. 2 Dutton v. Poole. 16782 Lev. 210, 83 ER 523. 3. 1861 1B and S 393, 121 ER 762. Full support of the House of Lords in 1915 in the case of Dunlop v. SELF-IDGE. Here the plaintiff had sold tires to D, one of the terms of the sale being that D would obtain an undertaking from any person buying tires from him for resale that he would observe the plaintiff's list prices. D having sold tires to the defendant from whom he obtained such an undertaking, the court held the plaintiff could not enforce the undertaking, not having been a party to the contract with the defendant nor having furnished consideration for the defendant's promise. In the often quoted words of Lord Haldane, in the law of England certain principles are fundamental. One is that only a person who is a party to a contract can sue on it. Our law knows nothing of a jus quaesitum tutio arising by way of entr'acte. Lord Haldane admitted that such a right may be conferred by way of property, as under a trust, but it cannot be conferred on a stranger to a contract as a right to enforce the contract in personam. The possibility of creating third-party rights by way of property, in particular by way of trust, will be dealt with separately below. With regard to the possibility of a right of action by the third party based on contract, the rule denying such a right can, since it's sanctioned by the House of Lords, be abolished or amended only by legislation. A question which was fully clarified only in such a recent case as in re Shebsmana is the effect of the rule in Dunlop v. Selfridge on the right of the third party. Does the denial of a right of action to the third party affect the validity of the contract in favor of the third party? As was pointed out in both the High Court and the Court of Appeal, there is no rule of English law invalidating third-party contracts. Until the promisor is released from his obligation by the promisee, or until there is a cancellation of the contract by agreement between promisor and promisee, the promisor is bound to carry out his promise in favor of the third party. What, then, are the remedies open to the promisee in case of the promisor's default? Can he bring an action for damages, and if so, can he recover substantial damages? The question was dealt with in West v. Houghtonell where the promisee, although held entitled to damages, could recover nominal damages only, On the other hand, EWHC, as he then was in re Shebsman, expressly reserved the question arising out of West's case whether more than nominal damages could be obtained by the premise. 4 I-9151 AC 847. 5 Ibid. At 853. 6 119,431 ch. 366, I-9441 ch. 83. 7 1879 LR4 CPD 197. 2. The trust concept as the basis of the third party's right. English courts have taken a more favorable attitude to the third party in those cases where the premise was held to be a trustee for the benefit of the third party. This equitable exception to the common law rule regarding jus quaesitum tutio was recognized long before the common law rule became firmly settled. The equitable rule is usually traced to the case of Tomlinson v. Gill. Here the defendant had promised the administratrix of an estate that if she allowed him to join in the administration he would make good any deficiency in the assets to pay the debts. In a suit by a creditor on the promise, Lord Hardwicke ordered payment on the ground that the promise was for the benefit of the creditors, and the administratrix was a trustee for them. In trying to define the limit of the equitable rule, mention should next be made of the case of Gregory and Parker v. Williams. Here, P, being indebted to both W and G, assigned all his property to W, who promised P to pay a certain sum owing by the latter to G. W. Having obtained the property, but failing to implement his agreement, G and P joined in a suit to obtain specific performance. Upon the principle set out in Tomlinson's case, this was decreed. After the passing of the Judica Tor Act, the doctrine evolved by equity for safeguarding the rights of a third-party beneficiary received the full support of the Court of Appeal in the important case of Lloyds v. Harper. Lo, here the Committee of Lloyds sued the guarantor of an underwriter who had defaulted on certain policies he had issued. The court rejected the argument that the plaintiff had suffered no injury but allowed Lloyds to recover the full amount due to the policy holders. Lush L.J. went so far as to declare, I consider it to be an established rule of law that where a contract is made with A, for the benefit of B, A can and E on the contract for the benefit of B, and recover all that B could have recovered if the contract had been made with B himself. On the facts, the House of Lords reached a similar solution in Les Affreiteurs Arcunus S.A. C. Leopold Walford Limited LL. Here a broker had negotiated a charter party which contained a clause providing for payment of commission by the owners to the brokers. Regarding the charterers as having entered into the bargain in the interest of the brokers and as their trustees, the House. 8 1756 Am. 330, 27 ER 221. 9 1817 3 Mayor. 582, 36 ER 224. 10 1880 16 ch. D 290. 11 I 9191 AC. 801. Of Lords held that the charterers, as trustees of the promise for the brokers, were entitly ceded to enforce payment of commission to the brokers. The subject matter of the trust in all these cases was the contractual promise made by the promisor to the premise, a chose in action. It is worthwhile noting that in none of the above cases had the word trust been used by the parties. However, by recognition of the trust concept as the basis for the creation of third-party rights, the courts had put themselves in a position where they could give recognition to such rights whenever they considered such a trust to exist. Had the courts followed a consistent line in recognizing the existence of a trust in third-party contracts, English law would have reached the position where third-party rights would generally be enforced, though in a roundabout way. However, what has made the law with regard to the recognition of third-party rights based on trust particularly unsatisfactory is the uncertainty as to the principles which will guide the courts in deciding whether or not such a trust exists. For example, in the Privy Council decision in Vanderpitt v. Preferred Accident Insurance, 12 a promise by the defendant company to be to hold insured against third-party claims those persons who used B.S. car with his permission was held not to confer any rights on B.S. daughter who was involved in an accident while driving B.S. car with his permission. This decision, which is hard to reconcile with Lloyds v. Harper, was based on the reasoning that the intention to create a trust of the contractual promise must be affirmatively proved, and there had been no evidence that B had any intent, to create a beneficial interest for his daughter. The need for such affirmative proof was even more emphasized in IN 7 Shebsman. In the words of Duparc L.J., the court ought not to be astute to discover indications of such an intention. 13 Deni of the creation of a trust here enabled the third parties, the widow and daughter of the promisee, to keep payments made under an agreement which otherwise would have been handed over to the premisee's trustee in bankruptcy. CV. However, in the cases quoted earlier, the courts did not insist on strict proof of intention to create a trust. As Uthwak J. himself said in IN re Shebsman, 14, the cases, no doubt, are hard to reconcile, but, to my mind, our explanation of them is that different minds may reach differing conclusions on the question whether the circumstances sufficiently show an intention to create a trust. There is much persuasion in Professor Winfield's cynical comment, when the courts wish to enable the beneficiary to sue they make the promisor a trustee. 1-2 I-9331 AC 70. 1-3-119441 ch. 83, at 104. 1-4 I-9431 ch. 366, at 370. And when they wish to prevent him from doing so they fall back on the shibboleth of privity of contract. 15 The only area of certainty appears to be where affirmative proof exists as to the creation of an express trust. Beyond that area the position is today as uncertain, and therefore as unsatisfactory, as it was in 1937 when the Law Revision Committee said, after a review of the case law in this field, we feel that this summary of cases, and many might be added to those we have cited, will at least have made one point clear, and that is that the law on this point is uncertain and confused. For the ordinary lawyer it is difficult to determine when a contract right may be conferred by way of property, in Viscount Haldane's phrase, and when it why notat. 16. Admittedly there may be advantages in certain cases not to hold that the third party has acquired a jus quaesitum titio by way of trust. In 1 Escheb's Nan was a case in point. In re Miller's argument 17 was another. HCRE property would have become subject to estate duty and succession duty if the third arties, vir held 1. 0 have acquired a beneficial interest. ELO IVCR, stay cases as exceptional, AI-D in the great majority of casts it woe. LTIBEL won the interest of the third pasty to acquire a directly and foresee, ABLC right. THCREA, of course, certain disadvantages at T, zir. G to the conference ERRLQ of third part. Rights by ray of trust. First, I-E. C is the procedural I. RC tilde. SSITY for the trustee party RCJ in the promisee trustee 8ly. As plaintiff or as defendant, FNR according to the pre-SIPPs or equity the contract is always enforced in the name of the trustee. Then there is the disadvantage that once the promisee is considered to hold the benefit of the contractual promise in trust for the third party, the promisor and the promisee cannot cancel the contract, however desirable it may be for them to do so. It is here that the use of the trust concept for the cray. Tian of third-party rights often gives that party more than the parties to the contract intend. 3. Statutory basis of the third party's right. In a number of special cases where the legislature felt it imperative, third-party rights have now been created by special statutory provision. This applies to life policies for the benefit of the insured person's spouse and children, to workmen's compensation, and to motor car insurance. A statutory provision which has been suggested as the basis for giving a third party a general right of action is Sec. 56 of the English Law of Property Act, 1925, and its Australian counter. 15 Province of the Law of Tort 107. 16 SKTH Interim Report 28. 17 I-9471 ch. 615. Parts for example, Sec. 56 of the Property Law Act Victoria, Sec. 36 of the Conveyancing Act, 1919-1953, New South Wales, etc. Under this section, a person may take an immediate or other interest in land or other property, although he may not be named as a party to the conveyance or other instrument. Despite the wide language of the section, the courts have given it only a limited effect. They were guided in their attitude by the history of the section. Its predecessor, Sec. 5 of the Real Property Act, 1845, 8 and Gvict. C.106. which was in similar though more restricted wording, was enacted to enable a person to sue who was not named as a party to a deed, but with whom a covenant in the deed purported to have been made. Sec. 56(I) of the Law of Property Act, I 925 is in somewhat wider terms than Sec. 5 of the 1845 Act, for it added the words, or other property, and, or agreements. Does this enable any third party for whose benefit an agreement regarding property has been entered into to bring an action? This view was rejected in White v. Bijou Mansions Limited L8 and in a number of other cases which were reviewed by Win Parry J and in Re Miller's agreement. A somewhat extended application was given to Sec. 56 by Danckwerts J in the case of Stromdale T3 Ball Limited v. Burden, 1 degree where the covenant which was enforced was not strictly made, with the plaintiffs, but it was a covenant that on demand by the plaintiffs the defendant would assign her leasehold interest to the plaintiffs. However, there is no doubt that the English courts would not take up the suggestion of using Sec. 56 to enable third-party beneficiaries generally to bring an action on an agreement made for their benefit. It was left to Denning L.J. in the recent case of Drive Yourself Hire Company. London, Limited v. Struzzo to state the view that the addition of the words, or other property, and, or agreement, in Sec. 56 had changed the whole law regarding third-party contracts. I can think of no words more apt to do away with the rule in Tweddle v. Atkinson, leaving the courts free, in cases respecting property, to go back to the old common law, whereby a third party can sue on a contract made expressly for his benefit. Although in the writer's view the granting of a statutory right of action to a third party is highly desirable, Sec. 56 is not the appropriate vehicle to bring about this change. If Sec. 56 had the alleged revolutionizing effect, a new anomaly would arise in the field of third-party contracts. There would be one law for instruments with regard to property, and another law for other contracts. 1937 ch. 610, I 9381 ch. 351. 19, I 9521 ch. 223. 20, I 9531 3 Weekly LR 1111, at 1118 A Seek. 4. The need for law reform. In view of the present state of the law, the need for reform of the law relating to third-party contracts appears as urgent today as it was in 1937 when the Law Revision Committee made its recommendations. The committee advocated the giving of a contractual right to the third party, so that it would no longer be necessary to resort to the trust concept with its concomitant disadvantages as the basis of that right. At the same time, the committee placed limitations on the third party's right. In the words of the committee's report, the unanimous recommendation was that where a contract by its express terms purports to confer a benefit directly on a third party, the third party shall be entitled to enforce the provision in his own name, provided that the promisor shall be entitled to raise against the third party any defense that would have been valid against the promise. The committee further recommended that the rights of the third party shall be subject to cancellation of the contract by the mutual consent of the contracting parties at any time before the third party has adopted it either expressly or by conduct. By referring to l'express terms of the contract, the committee intended to exclude third-party rights arising merely by implying a term into a contract. The provision regarding the party's right of cancellation was to remedy one of the defects inherent in the use of the trust concept for third-party rights. Legislation along the lines of the committee's report would place the law regarding third-party rights on a more certain and direct basis. 1.1. Continental law. Whereas Roman law generally did not enable parties to a contract to create a right for the benefit of a third party, modern continental law has taken a more liberal view. Not only do the codes recognize the principle that a third party may acquire a directly enforceable right under a contract, but the courts have given the relevant code provisions an increasingly generous interpretation in favor of third-party rights in a number of typical fact situations. The change in the attitude of the legislator of 1900 German Civil Code compared with that of 1804 French Civil Code is significant. French law. With even more than its customary brevity, the Code Civil deals with contracts for the benefit of a third party in a single article of the Code, art. I-12I, in derogation of the general principle of the Code, art. II-19, that contracts create rights and duties only for the parties, art. I12I enables a person to make a stipulation pour autrui, a stipulation for the benefit of a third party, if that is the condition of a stipulation which he makes for himself or of a gift which he makes to another person. Particularly from the 1860s on, French courts gave Art. I-121, which has been described as unnecessarily restrictive, a most extensive interpretation in favor of third-party rights by implying the condition of Art. I-121 in a number of cases. As a leading commentator says, nos tribunaux sont montub, en toutes setlanati and re, anims de in esprit tr and s large atr 6 is progressif. La stipulation pour autrui est devenu un instrument juridique de premier ordre, elle a servi dcjpou servira encore à faire fonctionner des institutions ou à utiliser des opérations qui seraient impossibles ou, tout au moins, plus difficiles avec tous les autres principes du dr it. The stipulation for a third party proved of the greatest importance in the field of insurance law, and most of the specific rules dealing with the rights of the three parties concerned in the stipulation pour autrui were developed by the French courts in connection with cases involving insurance for the benefit of a third party, a field now regulated by the insurance law of 1930. Typical cases in which the courts have held there was a valid stipulation for the benefit of a third party are, for example, a life insurance for the benefit of the widow and children of the insured person, a policy of marine insurance for the benefit of the owner. At the time of the loss, a stipulation in a contract for the sale of a business that the buyer will continue to employ certain members of the staff. 22. In cases of contracts for the transport of a person by land or sea, the courts have implied a stipulation pour autrui in favor of the dependents of the person transported, to the extent that in case of that person's death in a transport. 2.1.2 Ripert Boy Lancer, TRAITFELEMENTAIRE de droit civil de PLANIOL 4th ed. 1952 2-74.4 RT. 1119. On any pute, en general, sengager, ni stipula en son propri nom, q pour soi mpme. Art. 1121, en pute parallèlement stipula au profit de intiers, lorsque tel est la condition d'une stipulation clou en fait pour soi mpme ou d'une donation q en fait en autre. Celui qui a fait cette stipulation ne pute plus la revoquer si la tiers a dc class 6 vouloir en profiter. 22 Amos A. Walton, Introduction to French Law 172-173. Disaster. The dependents were held entitled to bring an action for damages against the transport company. 2 The nature of the third party's right is not explained in the code, and various theories with regard to such right have been advanced by jurists. However, a leading decision of the Cour de Cassation in 1884 dealing with the right of a third party under a life insurance contract laid it down that such a right is a droit propre, a right based directly on the stipulation. In particular, the court held, such a right had at no time passed through the premises estate. 24. French courts have also held, in harmony with the view taken by textbook writers, that the third party acquires the right immediately on conclusion of the contract. No acceptance or ratification on his part is required. However, acceptance or ratification is of considerable legal significance as it makes the third party's right secure against any revocation. According to the express provision of the Code Art. II2I, par. 2 The right given to the third party may be revoked by the stipulator at any time before the third party has declared his intention of taking advantage of the benefit. On the other hand, the courts have interpreted the requirements for such a declaration in a lenient way. No form is required for the declaration, it may be made to the stipulator promise or the promisor, and it may be made even after the death or bankruptcy of the stipulator. This has proved of particular importance in connection with contracts of life insurance for the benefit of third parties. The right to revoke the third party's right prior to the latter's declaration of acceptance has been held to be a personal right of the stipulator. T may not be exercised by the stipulator's creditors in case of his becoming bankrupt, however, in case of his death, his heirs may exercise the right. It has been held that usually the stipulator does not require the promiser's consent to revoke the third party's right unless this has been agreed upon. However, such an agreement may be implied, e.g., in cases where the promisor has a personal interest in the execution of the promise. French law allows the promisor the same defenses against the third party as he would have against the stipulator. In case of a defense based on non-execution of the stipulator's obligations, the 2 RIPERTBOULAXGER, of Cit. 225. With regard to the rights of spouse and children, C2COLIXCAPTTAXTTELAX_ORANDIERE. COITRSELEMENTAIRE. Detroit Civil Frank, A1I0STH ed. 1948 155. And I-9331 Dallows. RRCT ALP 137 to 140. 2.4 This is now specifically laid down in Art. 67 of the Insurance Law of 1930. 252 Ripert Boulanger, Op. Cit. 230 to 231. Third party may obtain judgment by executing the stipulator's obligations towards the promissory. 26. Who can sue for performance of the stipulation pour autrui? Generally, once the third party has made his declaration of acceptance, it is only he who can bring an action. However, it has been held that the stipulator may sue if he has some special interest of his own in performance. Where the action is for damages for non-performance, the stipulator can claim only the damage caused to him. The damage caused to the third party would have to be sued on by the latter. On the other hand, if the third party's right is effectively revoked, the stipulator is generally held entitled to demand performance of the promise for his own personal benefit. It has been suggested that such a demand may be defeated if it can be shown that the promisor had made the promise only in consideration of the third party, or that performance to the stipulator instead of to the third party makes his commitment more arduous, or that it alters the nature of the position created by the stipulation. A 7. 2. German law. Even before the introduction of the German Civil Code, the principle that a third party acquired a direct right of action whenever the parties to a contract so intended was recognized fairly generally. 28a. Which was not clarified until the introduction of the Civil Code in 1900 was whether a special affirmative act, such as an acceptance, adoption, or ratification, was required to vest the right in the third party. The Code not only decided this point but gave, in arts. 328 to 335, a far more detailed regulation of the field of contracts for the benefit of third parties than the French Code had done years before. 26 Ibid. 236. 2.7 Ihud. 234. 2 colon CAPITANTDLEAMORANDIERE, Op. Cit. 161. A recent codification based on the French Civil Code, the Italian Civil Code of 1938, may be quoted for an additional provision of interest. Accordance to Art. 1411, par. 3, of that code. In case of revocation of the stipulatio tilde or refusal by the third party to take advantage thereof, performance is to be made for TL tilde e benefit of the stipulator, unless this is contrary to the intention of the parties or to the nature of the contract. 117 Caso di revoca della stipulazione di rifiuto del teso di profittare, la prestazione rimane a beneficio del zero stipulant, salvo che diversamente risulti dalla volontà del party o dalla natura del contratto. This code also lays down in far more general terms than the French code that a stipulation for a third party may be made whenever the stipulator has an interest therein. E valica la stipulazione a favor di un teso, qualora lo stipulant vi abbia interesse. 282 Execuris Kip Wolf, LEHRCUCH des EUERGERLICHENRECITTS 13th. ed. 1950 137. Art. 328 lays down the general principle that a third party acquires a direct right whenever a stipulation to that effect is contained in the contract. Failing such express stipulation, the Code says that it is to be gathered from the circumstances, in particular from the purpose of the contract, whether the third party is to acquire the right, whether the right is to accrue immediately, or only under certain conditions, and whether any right is reserved to the parties to the contract of revoking or modifying the third party's right without his consent. The Code has thus left it wholly to the courts to determine whether in the circumstances of a case it is to be assumed that the parties intended to give the third party a direct right, or whether such a right is limited in any way. The courts have held that whenever performance is agreed on in the sole interest of the third party is presumed to have acquired a direct right without condition or limitation. Generally, the tendency of the German courts has been, especially during the last 30 years, to base the decisions, failing any clearly established intention of the parties, on the purpose of the contract as interpreted by the court. This has led generally to the recognition of direct third-party rights in a number of important types of contracts. Cases decided by the Reichsgericht in favor of direct third-party rights include the following. A father bought railway tickets for himself and members of his family who were traveling with him. The latter were held to be third parties with a direct right of action against the railway ADMINISTRATIN. Members of the family of the tenant of a flat were held in a number of decisions to be third parties with a direct right of action against the landlord, e.g., for damage suffered as the result of negligent lack of repair of the staircase in the block of flats. 30. A contract between the owner of a block of flats and the local municipality for the supply of water to the premises has been held to be a contract for the benefit of the tenants of the flats, giving them a direct right of action against the MNICIPALITY. A contract between a father and a doctor for the medical treatment of his child, and a contract between a father. 29 Entscheidungen des Rechtsgerichts in Zivilsachen, hereafter quoted as RGZ Volume 87, 64. 30 RGZ Volume 91, 24. RGZ Volume 102, 232. 31 Reichsgericht, in Juristische Wochenschrift 1937737. And the headmaster of a school for the child's education, were held to be contracts for the benefit of the INA contract of employment under the terms of which an annuity was promised to the employee's next of kin in the event of the employee's death. The next of kin were held to be third parties and were thus able to sue for the annuity. 33. INA case in which a prospective father-in-law promised his prospective son-in-law that he would pay his daughter the sum of =U marks on the day after the marriage. This was held to be a promise in favor of the daughter which she was then able to. On the other hand, there have been conflicting decisions as to whether the opening of a bank account in the name of a third person creates a direct right in that person. The Reichsgericht has held that where a bank book is issued for the LC count, there is a prescription in favor cf. A third-party right only IITHR third, greater than RT holds the in cases of life ins. Rance ANC. Annuity code attracts the code lays down a presumption in favor of direct third-party rights whenever tile payment of IH-INS-IRA-C, NCIII, near, tick. I. Annuity is stipulated to $2 made. To ATILIDP Son. I. J. Court. Hick. RCIIQJ to THC Law Art, IIISCR2 Lear. E. Contracts Art. RC. Re. Senior Rig. And approximately 6, Naic unaffected 2. Renungatio of H. Illassured parties I. Lillaret, NCC High the third party. Insurance monies and annuities do not form part of the estate of the insured person in such cases. The third party acquires provided that this was, according to Art. 328 of the Code, the actual or presumed intention of the parties his rights direct from the contract. No act, nor even knowledge of the contract, is required on his part to vest the right in him. 36 However, he may renounce the acquisition of the right by making a declaration to that effect to the promisor, and in such event the right is considered as never invested in the third party. Art. 333. Any revocation of the third party's right can take effect only if a power of revocation has been reserved at the time of the making of the contract. According to Art. 332, a promise who has reserved to him. 82 R. G. Z. Volume 153, 177, RGZ Volume 127, 223. 33 Reichsgericht, in Hania 1923-24, number 170. 3 4 R. G. Z. Val 67, 306. 35 The references to Clisizio is high. The Reichsgericht are based on 3 ESSECC USKPPW LFF, OF. Sit. 141 to 142, and 1 MANUAOLF German Law HMSO 1950-73. 362 Ennekerus Kip Wolf, Op. Sit. 145. Self. The right to substitute another third party for the one named in the contract may exercise such right by act inter vivos or by will. The code also contains a special provision, art. 334, that defenses available to the promisor against the promise are available to him also against the third party. A final provision, art. 335, deals with the right of action of the promise. According to this provision, the promise is entitled, unless a contrary intention of the parties to the contract may be inferred, to sue for performance in favor of the third party. This right is quite independent of the third party's right to sue the promisor himself. In conclusion, it may be said that from a comparative viewpoint the most interesting features of the French and German law regarding third-party rights appear to be at the extent to which French jurists and courts, la doctrine and la jurisprudence, have overcome the restrictive provisions of the Civil Code. b. The avowed tendency of both French and German courts in favor of protecting the third party by granting the party direct rights in a number of typical fact situations. JLEYSER. Dr. Jur. Freibzug, LL.B. Melbo Cern, barrister and solicitor, Victoria, independent lecturer in Comparat Law, University of Melbourne. 1951–1952, senior lecturer in law, University of Melbourne, 1952. 5.1.